Don't make sure. Good morning, everyone. Thank you again for your courtesy. Have a seat. We'll get started. We are on the record. And for the record, today is the 26th day of October 2023, and we are reconvening in the case known as State of Ohio Plaintiff versus Robert Franklin Young III, defendant. It is case number CRB 2301403A and C, relating to the two counts in the remand order from the grand jury of Summit County. Count one, domestic violence, misdemeanor of the first degree, and count two, assault, also a misdemeanor of the first degree. The alleged victims in count one, Tina Louise Young, Mr. Young's spouse, and in count two, Michael Lee Young, Mr. Young's brother. The court, of course, has considered this case without the intervention of a jury, Mr. Young having waived his right to a jury in this case. And in the 40 or so hours since we were last together, Mr. Young, I don't think it's hyperbole for me to say that I've spent a lot of time with this case. Over the years, I've assumed this role in many cases where there weren't jurors. Where I was, in fact, fulfilling the function of the jury, had they been in panel. And I've taken that responsibility very seriously, and I hope you understand that. I'm going to, of course, announce the verdicts. I'll reduce my verdicts to the form of a judgment entry, which will be filed at the clerk's office and then distributed to you and your attorneys. And then we've got two other cases that I want to indicate. I would want to speak with Ms. Roberts, Mr. Callahan, and Mr. Grevin on those other two cases that remain unresolved after we're done in the court this morning. So If council will be kind enough to join me in chambers after we're done here in the courtroom to discuss those two remaining cases. Any problem doing that, Ms. Roberts?
No, no.
Mr. Grevin, Mr. Callahan?
No, no, but would it be the court's intention to go back on the record after that, or just discuss in chambers?
Just discuss in chambers. If there is a need for a record proceeding, of course, we can always come out into the courtroom, Mr. Callahan. Okay. All right, I'm going to announce the verdicts in reverse order. I'm going to announce the verdict on count 2 first. That is the allegation of your knowingly causing or attempting to cause physical harm to Michael Lee Young on July 7, 2023. We all saw the encounter at Michael Young's home multiple times. I have reviewed it again after we were in the courtroom. And I want to make it very clear that, first of all, what has been described as a hot arrival at Michael Young's home by Mr. Young in his pickup, I would suggest is more lukewarm, even tepid. I did not find that to be of concern at all. I just want the record to reflect that. I also, in reviewing that tape, I have come to the conclusion that Michael Young, who testified he was not going to let you into his home, was successful in that endeavor. And I did not find, and do not find on this record, that you were an aggressor in that encounter. I'm not suggesting Michael Young was an aggressor. I'm suggesting Mr. Young indicated he lowered and charged when it was apparent to him you were going to come by him and go into the home. That was the way I saw that. So I am going to acquit you of that charge of assault, finding that the state's failed to prove beyond a reasonable doubt each of the elements of the crime of assault relating to the encounter with your brother, Michael Young. Now, going to count 1 of the indictment, where you are alleged to have knowingly caused or attempted to cause physical harm to your spouse on July 7, 2023, she being a family member. That was a much more difficult call for me. I want you to know that I reviewed the testimony of all the witnesses, including your testimony and the notes that I took at the trial. And there is one defining moment in the trial as it relates to count 1, Mr. Young. And that is the moment when you indicated that you believed your daughter Abby was a liar. That caused me, and has continued to cause me, emotional upset, quite frankly. To see a father indicate that his daughter was a liar, it brings a whole lot of emotions and family dynamics into play that you and your family are going to have to resolve going forward. But I want you to know that I did not believe Abby was a liar. Her testimony was compelling. She was, in my conclusion, an eyewitness to your having struck your wife. And that the conduct of your wife and Abby after that event, portrayed in the videotape, corroborated what I believe occurred, and that is that physical contact with your wife was not incidental, as I believe you characterized it, but I believed it was knowing and in a moment that I know you would love to take back, but can't, caused some physical harm to your wife. So I'm concluding that you are guilty beyond a reasonable doubt of that count of domestic violence. Now, a lot of things come into play at this moment in time. I'm not going to proceed to impose a sentence in this case. We have the 2 unresolved cases, and I expect that we're going to get those resolved however it's done, and then I will be prepared to proceed to impose sentence in this case. That means that the protection order that's in place relative to your wife, who is the protected party under that order, will continue going forward. We will endeavor to resolve the two remaining cases, however that would be by jury trial, or by bench trial, or otherwise. But we're going to take care of that business, get all of these cases resolved, and then we will come back to this case and the imposition of sentence, which of course won't occur until Ms. Roberts, the victim, your spouse, your family members, they're all significantly impacted by these events, and you, in terms of what I need to hear before I would impose what I believe to be an appropriate sentence. That having been said, you of course will be informed then, but I'm telling you now, you'll have the right to appeal decisions I've made in this case, the verdict on count 1 of guilty beyond a reasonable doubt. All of that would be subject to appeal, things you'll discuss with your attorneys, which will directly impact how we're going to proceed in getting the sentence imposed and carried out, always subject to a stay while an appeal is taken. So we're not going to resolve the case today, but I can assure you that I'll be prepared to do that and to have the opportunity to listen to Ms. Roberts and her presentation relative to what she believes an appropriate sentence would be on count 1, listening to Mr. Callahan and Mr. Grevin and to you and anyone else that you would bring to the court to give me information that will allow me to fairly and impartially impose a penalty that I believe would be appropriate, commensurate with the crime that's been committed. And no one is suggesting that there was serious physical harm suffered by your wife, or you would have been charged with a felony crime. But I have concluded there was that physical contact and that it was not incidental. But we'll hear more about that from your attorneys and Ms. Roberts on another day. So let me pause there and ask Ms. Roberts, is there anything that I've said thus far now that you're taking issue with or suggesting that we should do things differently procedurally?
No, Your
Okay, thanks, Ms. Roberts. Mr. Callahan, Mr. Grevin, anything?
No, Judge.
All right, Mr. Young, any questions about what I've just told you?
No question.
Okay. Now, I'm going to ask you to remain where your attorneys can find you by telephone or wherever, staying close. And I'll be speaking with Ms. Roberts, Mr. Callahan, Mr. Grevin, and Chambers on the remaining cases. And if there is no further on-record proceedings in those cases today, we will not come back into the courtroom. If there is, we will. So we'll adjourn now. Thank you. And I'll see Counselor in Chambers.